Imagine, just for a second, that you've been convicted of a crime, right? You firmly believe the trial was flawed, and you need a higher court to review your case. But before you can even make your argument, you hit a massive wall of procedural red tape. You're basically told you need to ask for permission just to file your appeal. So here's the big question. Could a seemingly simple administrative hurdle, like needing permission to appeal, actually compromise your fundamental freedom? It's a totally fascinating question, and one that gets right to the heart of how we balance systemic efficiency with individual human rights. Welcome to The Explainer. Today, we're breaking down an absolutely monumental judgment from the Constitutional Court of South Africa. It's the case of Hans-Jürgen Steyn versus the state. I absolutely love digging into constitutional law because it's exactly where abstract ideals crash into everyday reality, and this case hits the nail on the head. We're going to look at how the highest court in the land evaluated a law that acted like a literal gatekeeper to justice. And as you'll see, we'll discover why the specific context of where a trial takes place matters immensely. Okay, here's our quick roadmap for today. We're going to kick things off with the right to appeal, then move into a tale of two courts. After that, we'll tackle the petition problem, dive into striking down the law, and wrap it all up with a managed transition. All right, let's jump right into Section 1, the right to appeal. So, at the time of this case, Sections 309B and 309C of the Criminal Procedure Act created what was basically a strict permission gateway. Let's say you were convicted in a magistrate's court. Well, you couldn't just automatically appeal to a higher court. No way. First, under 309B, you had to apply for leave, which is really just fancy legal jargon for permission, from the very same magistrate who just convicted you. And if that magistrate said no, well, your only backup plan under 309C was to submit a written petition to the high court, essentially begging them to let you appeal. Now, this wasn't just some theoretical textbook problem. This brings us to the actual applicant, Hans-Jürgen Steyn. Steyn was convicted in a regional magistrate's court and handed a pretty substantial prison sentence. He firmly believed he had solid grounds for an appeal, but he got caught right in this trap. He asked the magistrate for leave to appeal, and, surprise, was denied. So he petitioned the high court and was denied again. Having the door slammed in his face at both lower levels, he took his fight straight to the Constitutional Court. His argument? That this whole permission structure completely denied him his right to a meaningful hearing by a higher court. That brings us to Section 2, a tale of two courts. Okay, so the main defense from the state was actually pretty straightforward. They argued that a very similar leave to appeal process already existed for the high courts, and hey, the Constitutional Court had previously ruled that that one was perfectly legal. The state's logic was basically, if it's fair for the high court, it's got to be fair for the magistrate's court, right? Well, not exactly. Justice isn't a one-size-fits-all kind of deal. The Constitutional Court pointed out some massive differences. High courts have inherent jurisdiction, lighter caseloads, and usually deal with people who have experienced lawyers. But magistrates' courts, they're what we call creatures of statute. They operate under immense, crushing pressure, and they mostly deal with everyday citizens who can't even afford a lawyer. The court actually went out of its way to highlight what it called the unenviable lot of a magistrate. Think about it. They face insanely heavy caseloads, work super long hours, navigate complex language and cultural barriers daily, and sometimes have to make do with really rudimentary library facilities. I mean, they're doing absolutely indispensable work, but under incredibly stressful conditions. Because of this high-pressure environment and the fact that a lot of folks standing before them don't have lawyers to mount a proper defense, the natural margin for human error is just inherently higher in a magistrate's court than it is in a high court. It's just a reality of the system. Moving right along to Section 3, the petition problem. Let's walk through exactly how this petition process works, step by step. Step 1, the magistrate denies that initial application for leave to appeal. Step 2, the accused drafts a petition, and the court clerk sends it on up to the high court. Sounds simple enough, right? But step 3 is where we hit a massive, glaring procedural flaw. The high court judges tasked with reviewing this petition usually have to do it without access to the full trial record. The law literally only required the clerk to send up copies of the refused application and the magistrate's brief reasons for saying no. The whole shebang of the actual trial, missing. To show why this is so dangerous, the judgment quotes a previous case, leaning on the words of Justice Didcot. He said, and I quote, "The refusal on that footing worries one. They will not learn of any procedural irregularities that may have marred the trial." Basically, without the trial transcripts, those higher judges are completely in the dark. They are essentially forced to just take the lower court's word for it. This structural flaw creates what the court brilliantly called the blind spot. And why does this matter for you and me? Well, think about it. If higher courts don't have the actual paperwork, we're talking the transcripts of who said what, the cross-examinations, the actual evidence, they simply can't see credibility issues. They can't spot hidden procedural flaws. They are literally blinded to the true merits of the appeal. You could have an unrepresented person drafting this rambling, incoherent petition that completely misses the legal point, while a genuine, terrible miscarriage of justice sits perfectly hidden within a trial record that the reviewing judges never even get to look at. It's wild. All right, let's get into Section 4, striking down the law. At the end of the day, everything in this case hinges on Section 35(3)(0) of the South African Constitution. It states, plain as day, that every accused person has a right to a fair trial, and that explicitly includes the right of appeal to or review by a higher court. The Constitutional Court looked at this and determined that because the petition procedure was so fundamentally flawed, especially because it lacked that crucial trial record and disproportionately hurt vulnerable, unrepresented people, it failed to provide a meaningful reappraisal. Therefore, it was a clear limitation on this fundamental constitutional right. Now, it's worth noting that constitutional rights can sometimes be limited, but only if the state can actually prove that the limitation is reasonable and justifiable. And the state definitely tried to do this. They argued that this permission process was absolutely crucial to stop clogged courts and prevent hopeless appeals from wasting valuable judicial time. And honestly, that sounds like a pretty fair point on the surface. But here is where the state's defense totally collapsed. They provided absolutely zero statistical evidence to the court to back it up. No data on the backlog of appeals, no resource analysis, nothing. Neutrally speaking, a court simply cannot restrict a fundamental human right based on an assumption. Because the state failed to justify the limitation with hard evidence, the Constitutional Court declared Sections 309B and 309C invalid. Which brings us to our final part, Section 5, a managed transition. So the court had a very practical problem. They realized that if they just struck down the law immediately, the high courts would suddenly be flooded with an automatic right of appeal for literally every single case overnight. That could completely overwhelm and crash the entire justice system. So they used a really clever constitutional mechanism. They suspended their declaration of invalidity for a period of 6 months. This basically gave the government and the legislature a half year of breathing room to draft a new constitutional law to fix the process properly. But you might be wondering, what about the people caught in the system during those 6 months? The court obviously wasn't going to just leave them completely unprotected. So they instituted mandatory interim rules specifically designed to protect the most vulnerable. It worked like this. During the 6-month transition, if an accused person was unrepresented by a lawyer and they were facing a prison sentence of more than 3 months or even an unpaid fine that would result in more than 3 months in prison, the clerk of the court was legally required to submit the full trial record and the magistrate's reasons for judgment to the high court, right along with the petition. This effectively removed the blind spot for those with the most to lose, keeping them safe while the government worked on a permanent fix. So what does this all mean, and what should you take away from this? Well, the Stein case is just a brilliant reminder that laws don't exist in a vacuum. A procedure that works perfectly well in a well-resourced high court, filled with seasoned lawyers, can literally become an engine of injustice in an overburdened magistrates court dealing with unrepresented citizens. It leaves us with this final, provocative thought to chew on. If justice is traditionally blind to bias, can it ever afford to be deaf to the context of the courtroom? Thank you so much for joining me for this explainer. Keep asking questions and keep learning.